the guidance.
Thank you. Discuss.
Lordship, medical constituted to remove him.
Yes, next.
If that only delay, Lordship, there is a full.
Discuss. Yes.
Yes, Your Lordship. Very interesting law. Once the MSM assumes jurisdiction and the resolution is under the Act, be a partial reference to the private, because the whole purpose of the MSME
was arguing that was from where the jurisdiction
here
lies
also
on certain.
and Bangalore.
identical Jammu and Kashmir.
The matter which
Yes.
somebody that MSME thing.
I think direction. I was also in that MSME matter.
Jurisdiction.
You don't know which matter.
Your Lordship, as per the
No. That's a different.
has now been directed to decide my on merits expeditiously, so there has to
In the meanwhile,
oblige, Your Lordship.
along with me, we will not. We shall know whether they are post.
As of now, it is
Post along.
it is not identical, then
We'll leave it together. It's always,
And Your Lordship,
we have granted.
oblige, Your Lordship.
will determine the seat of arbitration for the court, party order.
The jurisdiction. Right. And second thing you were saying of arbitration clause, where situated that jurisdiction.
Right.
Then it will. We keep it. How many times we keep on?
But
You close it. You sit together and
Well, it's
analyze it.
Unfortunately,
We'll close this.
well, that I probably have a request today because the AR.
well, this time there was
Last
that previously what was happening, we couldn't finish. Penultimate clause is what we are left with. Grateful, deeply grateful, my lords. I hope.
Yes, sir.
Lower education and home guard is appointed by.
appearing online.
Who?
Swati appearing online.
Yes, we can hear you.
In this case, the Honorable High Court has said of respondent number 2 as home guard valets on the ground educational qualification. And government is in violation of the statutory. If I may just point to submit, Malaj, I'll just take 2 minutes. I just want to point out, Malaj, this finding that the 2000 directives, these are not mandatory. Number 2, that 2018 provides for clause 12. Now, it is held that clause 12 says ignore the statutory provisions. If 5 of the impugn order, High Court is shocking to note that clause 12 directs the district commandant by ignoring the. Now that finding is Malaj. What clause 12 actually?
Right person. So we will not.
They just submit Malaj. One more thing. This is not. These are district. It's supposed to district. The qualification of home guard is concerned. 2019, as per rules, qualification was only 7 years, 7 standard, and he from 18 till 23, same position. The post of district. It is only now has been set aside.
So, Swati, not a case for us.
The Honorable High Court with our appointment of the discretion of the government. Well, these are precedent because these are not the experience of qualification of graduation methods.
Small posts. Decided.
Well, I am the press Malaks, had it been any other post, ordinary post
There is also a decision of Deepankar Datta by itself
not so far as this particular post is
not a case and circumstances of the case. Interference of other in exercise of Article 136 of the Constitution. India, the question of law, Swati Divyal, is kept open for appropriate case, especially petition. Next.
Very well,
It's 26 years for the
Leave granted. Leave granted.
Because I'll request. This can be disposed of. Because it's a 10-year-old matter.
Please.
So I'll just tell you not
Shall we dismiss it?
No. Lines in the order, that will be that. I'll just explain. The issue was about seniority.
Just on the issue that you are
So
saying.
let's now both promote it. They're both on the same post. What the CAT has said, there is the error. It's page 1, PF 172.
Quantifiable data is the issue.
Is that in terms of Nagraj, there is innovation in promotion. All I'm saying is promotions in terms of Nagraj as one. Let that take place for future.
You see,
CAT's
CAT's order is not in law. Whenever tomorrow
Make Nagraj prospect.
no,
Can't make Nagraj prospective.
No, I'm not saying so.
we
Nagraj,
dismiss it. That's the best.
no, just dispose it of saying nothing survives today.
By passage of time, become
Very
infructuous.
well, very well.
Time SLP has become infructuous. As being infructuous, right? That should do.
At the law now.
Yeah, that's right.
No.
Therefore, whatever law
Please, my lords. Item 61, my lords.
we had a lot of question as to whether we store 34, number one,
Well.
additional evidence at the 34 stage. 34.4 is open-ended. There are 4 or 5 judgments on the point say that it is impermissible. What the facts of this case? Trying to complete opportunity.
Well.
It's were already taken on record and data to remove the technical directed you to constitute the AT. He will formally take those sale deeds on record be subject to 34, which we have restored. So it we have put it, though the judgment was fully on, but we thought it is best to decision making rather than a precedent making.
We are
I wanted
grateful,
to tell you. So therefore, bit of a duty. Tribunal gets constituted early because it's a named tribunal under the commissioner,
Please, my lords.
who would just take record and pass an order which will be award, and the other side 34, and the present order you have challenged under 34
Please, my lords.
as order which is going to be made.
Please.
Both will be before and disposed of.
Please, my
You
lords.
can explain.
Please, my lords. Grateful, my lords.
No, but you of challenging the.
We are grateful, my lords. Your lordship.
So just balanced.
Grateful.
I was in 27 months.
Compliance.
But certain cases, compliance has been done, they say. Orders have not been communicated, though they say that they have received the copy, madam.
No order of the reason given, there is no scope.
Anyway, the
1 minute. Maybe stage when an order has actually been, then whatever individual they will be subject to challenge.
that's what, that is why I am saying that.
Open to you.
Your lordship may direct
Will
them,
close
they may be directed to provide us the copy so.
It should be given.
Your Lordship, they are stating against the.
But I'll inform again, sir.
close this. We'll close and give you the opportunity.
Very
I think 20. You challenge what rectifications if you are not happy pursuant to our order. Where is that?
We have,
Affidavit कहाँ है दिखा देना?
which we have 51, 7 compliance of
compliance.
Chart is given.
affidavit of compliance.
Stated one reason that there is no there is assistant group D post.
1 minute, 1 minute.
Order categorically states that if there is no parcel porters jobs, then any provided to the employees.
And various and documents to show exist over there.
Not really.
In our cases,
Okay,
no
you-
compliance.
Yeah.
My lord.
Let them have a look at it. Sir, a copy of the with the annexures will be served list after 2 weeks. You and we will enable you to check.
Very good.
Grateful, Lordship.
Right? Come next week.
I have filed additional document. I also apply from my additional document because verification and date of the verification has been
After 2 weeks,
Yes.
the matter gets.
and that I will get your lordship after 2 weeks.
Great.
Point 16, my lord, there's an application. Yes, that is 27.16.
Come
Two
in.
applicants.
Here you are.
My lord, because in his case, records were produced by the railway. Now he has.
You have not also seen it. You also see the affidavit. We hear all of it.
Reply, my lord, may I give the IA number they can find?
But it will take some time.
After 2 weeks.
Then, go ahead, lordship.
So that in the last occasion, orally said that if there is, I spoke to the concerned authorities. Just suggest, my lords, 10th of May there's a local adalat.
Oh, very
Let the matter be. I will then give a formal suggestion to them.
good.
As per the order dated, my lords, that on 5th 24.
Our order.
Yes, where my lords 50% of the decretal amount if it can be. My lords will kindly see 5th of August.
Not on if this is for the Lok Adalat. When is it?
10th of
Lok Adalat. Okay. Lok Adalat to be constituted.
because PSU will also, that is how we
See after that.
deeply obliged.
Yes.
Deeply obliged.
My lords, in this, my lords, I am appealing for petitioner number 1, my lords Prakash. The advocate on record is my senior advocate, my lords. So I am in petitioner number 1.
Otherwise, what is to be done?
The file is also not with me, my lords.
Clear. Comments
After 2, not with the file. Yesterday, I have, my lords, my name is also not updated. Please, man.
Bearing in 29, my lord. Fourth adjournment, my lord. Yes, my lord, this is the fourth adjournment.
This are on 29.
Which one? 29th.
My lord is all
next
grateful.
13th.
May papers. For the petitioner, there are two matters here. With respect to the first matter, on behalf of the respondent, that is what I am. Now, what happens here is, mirrors.
After 2010 advertisement with you for firstly.
There is a first respondent, and on his leave, and he is not this department. This is the first respondent in the first matter. So the first matter, I request your lordships by leaving the question of law open, which has been raised by the commission. Number 2 matter, kindly be allowed to file a rejoinder.
There are 2 matters here.
2 matters, 30.1. That file a short rejoinder, that is required. That is why I am praying for that. First matter, lordships can dispose.
He is not interested.
Okay. 30 point. 30 may
30 can be disposed of.
of law kept open for weeks.
Yes. Disposed of.
31 we will.
File may counter in 30.1, my lords.
Then we would like to file a rejoinder.
Already filed. Already filed. I
Already filed it.
filed.
Filing a rejoinder list thereafter.
Lord, I proceed with the matter, my lord. I must say that Honorable Mr. Justice, in one of his, in the 877 day orders.
Bench in which one of us matters filed.
Hello.
This before another batch. Come
But it was only.
No.
Hello.
Once we are said.
Next.
Next.
Your body response.
Correct.
Correct.
That is settled.
Please allow.
Let's see. Let's
With the of hearing, they have an a few vacant posts. Submitted. I have submitted, made the statement. Palika had submitted on last occasion that there are mallards, posts mallards. So according to was directed to take instructions mallards. I've taken affidavit is also ready mallards. There are
Okay, very good.
now the present petitioners, petitioner mallards Divyank Yashwant.
That affidavit you have filed or you
I have it.
you file it and we will
Mallards.
have a affidavit. Take a post.
That will come connected.
In the meanwhile, file during the course of the day.
Please, ma'am.
My matter is also tagged, your lordship. My vacancy also.
Luck to you. All the very best.
Received a thank you. Thank you.
They might area.
I am not. I'm the fresh matters which were listed.
We are the initial. There are
We will see. To you will see. Best.
For more than 10 years as well, my lordship.
20 years. Your Lordship,
Okay.
I beg to appear for the private respondents in this.
Let them file that affidavit.
All-
That we will see how we can adjust.
All
27, 33, sorry.
My lord.
Yes.
Before the courts below, but I do not. So I filed an application to place a quietus. They asked for respond. They asked for time on the last occasion.
Millard, in this case, I am appearing for. Millard, yesterday we lay our hands on certain documents. And FIRs registered against.
One individual person. What is there for us to interfere in this? What is there for us to interfere in this?
In this case, the
just because it is what you say, the earlier 2018 dismissals are irrespective of the earlier order, at least the 2000 continues to subsist because there is no finding. That's the sum and substance of your argument.
The Honorable Division Bench mentioned in the orders, Millard.
There was nothing, there was no finding to that. But
Millard,
when has he been out of
Millard, since 2006.
Service, and they are challenge 3 sort of disciplinary inquiries. However, 2 have been decided in my favor. The 3rd has been decided in my favor.
You just because they have not been 2016, you close the chapter.
Yes,
that's the best thing. So we will leave it at that.
I have 1 year left.
Leave it at that. Especially petition is dismissed.
Millard, with respect, Millard, allow us to reply to the application, Millard.
This is one individual case.
Millard, they refer it back to the Honorable Division.
It is not a case for us to. Individual case that compulsory thrice over. Dismiss.
Millard, my lords may kindly, Millard.
She will be so.
Next. 34.
Before I'm seeking last opportunity to find, being able to have a contact with the client in this opportunity. Just give me 2 weeks. I have come to her, therefore I'm just requesting 2 weeks can be given.
Able to get certain.
My lord was initially protected even Halba and Koshti, my lords.
This Halba Koshti
an affidavit withdrawing the claim to a member of.
My lords, just 2 weeks time. As per the specialist petition, the content petition, the affidavit filed subsequent to the direction by the department. He has
okay, come next week. We'll discuss. 2 weeks.
Obliged.
35. Assistant teacher middle course. But we are actually
not joining the transfer. Any notice to her. Appointed to
division bench allowed the petition. No single judge, the petition division. What is this? No, notice has already gone. State school.
Hearing from the state in the.
Yes.
My lord, we've already filed counter affidavit matter, my lord. Certain, my lord, kindly give me 2 weeks.
What happened?
I'm for the state.
What happened to her? They might not be into the school. School तो अच्छा क्या करें इसको? Have it on some other day.
No.
Next.
In the meantime, I may be permitted to write a translated copy of the annexures.
Supposed to support the, because it's your order.
Yes,
Examine and tell us
my lord.
which was set aside
Yes, my lord.
after 2 weeks. After 2 weeks.
Please.
तो नेक्स्ट वीक कुछ मत लगाना आगे 2 हफ्ते के बाद लगाना लगा ठीक है नेक्स्ट
You oblige, my lord.
Everything has been served.
on what ground what happened in notice was issued for what reason
We are the aborigines and settlement policy of the frame.
who's appearing that being the ground huh? What is that
It has been a There has been a similar order here in Nitaram.
किसने दिया मेरा मैंने कौन अरविंद कुमार ऐसा होता है बुद्धि कर्मानुसार है ना कभी कभी कुछ he say I think he says he is tribal aborigine who lived in this land in Madhya Pradesh. Who is up here? Petitioner shall serve a copy of the specially petitioned Standing Council for the state of Madhya Pradesh after 2 weeks. We will see.
To them,
Serve it on them. Tell who is the tell.
okay, we'll
Yes,
My lord, we have been waiting
my service for the last one.
Huh?
Notice have been issued since
Serve it on them.
Please serve them, my lord. Many times I have served my lord.
Standing Council Madhya
can you
Pradesh.
please give us some?
May be served, Mr.
Serve it on Saurabh.
Can you give it also password?
Not now. Come.
They are in. Yes, my lord.
No, nobody will. What
Have been, notice have been issued since last.
happens? Just serve it on the Standing Council. We request Saurabh Mishra, the Saurabh Mishra to this register. Very well. You serve on him and next.
This that is special education, my lord. That's the difference.
This will be covered by
MA
justice.
Yes, my
Now
lord.
be covered by justice judgment. Have a look at it.
Equivalence cannot be discussed.
Persons who are
Especially in special purpose.
Equivalence cannot be.
It is not equivalence. Oh, that is a different case. But super speciality.
So here, my lord, the distinction is, my lord, that made in special education.
This speciality is a different speciality. SLP dismissed.
No, my lord. Look, this education, my lord, this is recognized by. There's a special council of parliament. You know, there's a council.
Oh, but then kind of a super speciality.
No, my lord. As per the government policy, there is a policy of inclusive education. Government institute or any government.
The post was available and which is the one which.
Absolutely not. Time to the advertisement, page 77. Page 77. Annexure P5. Serial number 2. Chart. These are the posts. Subject, vacancy, directly inclusive posts. There are total 7. There are 2 separate advertisements. So this special, amid special 3 was specially for this because policy also, Milord, page number. And then page number, Milord, page between NCT is the MEd and BEd course. Statutory organizations.
Mr. Natarajan, vacancies in this.
No, it's a categoric advertisement. 79.
That is the.
Very
It's not there.
It is categorically MA. That's all. MA.
We are asking the same.
If the subject, Milord, is the post, there is a special for that, Milord. The government of India recognize those people.
77, right?
78 and
Say it's a wrong single, just say it's a wrong advertisement. One hand, you are creating a policy.
You show us where is the advertisement. What's the correct?
Page 7 is the post. Serial number 2 in the table. Inclusive education. Dash of P5, Milord, page 77. Kindly have serial number, twice description of post.
Sir, education come to page 78.
Clearly there.
The qualification is M.
What
and
the
not
problem?
MA special.
Understand.
What would have been better?
I am also MEd plus
Special. You are a super in a way. Been trained as MA.
Milord, that's what every policy also says. MEd is these people they are taught for those 5% where in every institution in government is under the inclusive policy education, Milord. For that purpose, Milord. Already MEd, Milord.
You might have foregone for that. You might have.
Kindly have, Milord, the MOU, Milord. Kindly page 73, because this is important, Milord. The government policy says that this has 73. This is the MOU.
Not that.
Everybody has to follow as to the policy implemented, Milord, by the state government. This is the MOU, Milord. Kindly have.
Even the RCI.
Let me just kindly, Milord. Kindly have the before, Milord. This is between National Council and Rehabilitation and of India. These two organizations recognizes MEd and in special education. Kindly read fourth line from the preamble, Milord. One of them to bring children disabled.
Even a clarification subsequently.
And kindly see aim and objective, Milord. Aim and objective, page 74. Also, Milord, between these two organizations, curriculum of these two. Every institution, Milord, under the policy of the government of India, that 5%. So who will teach them?
The reserved 5%. It shows that it doesn't seem to be. We have.
That's why the signature says this is a wrong idea.
Okay, you are questioning the correctness of that. Correct?
Yes,
That's a different matter. Then you should challenge. That you should have actually advertised a particular post for that for inclusiveness. They have not.
They considered as well. In the select list, subsequently a letter came. In the letter from the government department came saying.
No, you are actually, it's a reverse. Your argument is a reverse engine. Because I have this inclusive clarification. Your post should have been for this reason. Illegal. That can't be done.
I am saying, Lord, I am eligible for all the posts. Because I am MEd, Milord, so therefore I am post. It is not that, Milord, I am filed where I have given the distinction between both the courses. It is extra because I'll be in a position.
So post is another matter.
I'm on the qualification.
They have also saying that it is not given a specific clarification. You have not challenged that.
That's what I've challenged that, Milord, saying that the government of India policy, Milord. That is my lord, because that is what challenge, my lord.
Section 37.3, 37.3, the main arguing here, my lord. My lord.
I'm 38.
38 on the wanted the state government to get instruction.
Kindly grant me last chance to file a complaint.
We are only doing adjournment. Nothing is happening.
For the state is concerned.
Since your lordships are
Yes, it is.
persons appointed along with them, they challenged before this honorable court and they
The university has lost all. What do you want for the present?
principle of law is parity. We have certain contentions to make, my lord. We not actually find that there is a parity applicable. Its response will be important because the other, my lord, relief was granted, my lord, in the contempt case because state has clarifications. Your lordships were pleased to speak to, my lord, assist your lordship. Yes.
One is you. This is only in the. How many people are there?
There are several petitioners, my lord, are lying in. Once the state files a response, my lord, your lordship effective relief to get. As I mentioned, that became the basis for this order. That case because it's not being completed. No, my lord, important submissions. But what the High Court does is it's to some other matter where a person was appointed in was granted, saying that it should be granted. This High Court says same parity principle will apply. Big points of distinction, I'll not rub your lordship. That person appointed in 2009, statutory rules framed providing payments will be made to the self-financing institute. It says if appointments made are under those rules will apply. These 2011, two different. But we say that applicable to the prior case, these rules. Number one. Number two. This was in pursuance of a regular conducted by the university where the person is the staff of the university.
What of these respondents?
Working with
but now people have been, they're working in society to which the university has transferred in 2017. They're getting whatever is the contract with that particular society. 2017. Now this is a historical. The university will today be mulcted with from 2011 to 2007. This is already this honorable. No, my lord.
Girish, it works for you. We don't just, we don't
make one thing. My effort
working for you.
Yes, my lord, my university, my lord, appearing before your lordships would be this as adversary will try to assist your lordships. This matter is still tottering in a contempt. There are various policy issues that are coming up considering separately. So this is not. I'm only saying let the state file a reasonable time. Next day will assist your lordships. Assist, my lord, the petitioners also getting.
What is it that they are asking?
What they are saying?
What is it ultimately?
They are asking
they are out of the world.
My lord, it's not crushing on the university in terms of finance. Have arranged our
the university doesn't have to spend on the teachers who are teaching.
The two things. But university
spend on your teachers.
It does. What it does is there are university-run colleges, university of self-financing institutions.
Pointed under the subsequent rules.
And whatever they are. But I'm praying for one request. To file an affidavit because if those policies, but I will not be arguing
the implication on me.
Implication on me is I will have to pay. But it's for 4 petitioners it may not. But this will become a precedent for several appointed in several colleges.
From their end,
Pending, and everybody is saying that parity which was followed in self-financing colleges. Extension and
Shashi, file your next week.
Within 2 weeks. This gentleman also, because the person the petitioners, they are all gone. 2009 appointment. 2010, along with the petitioners, page 61, 61.
So this.
Where the earlier appointed under the special rules 2000.
It's not correct. That is not correct.
Respondents are appointed under the special.
61, Lakshmi, kindly see.
70 not.
61, Lakshmi, kindly see the names.
It is 70 orders.
We'll take a.
Page, the persons appointed along with us.
You have sufficiently indicated to him.
Let's please written.
They can't see.
About stand on the same footing also.
Lordships kindly have this on any date after 5th. Deeply great.
Not corresponding.
Yes, sir. On for a long time, this matter. What's the present position?
Portion, but the interest is a dispute. There is no interest. We have said, and the
just want to use the 10-way representative.
Yes, sir.
Code number 4. Or password.
Passover, not today. We will have it on some. We'll have it on some. Today we have.
I have also something.
After 2 weeks.
Yes, after.
For the state.
4 weeks. 4 weeks. We will have it after 4 weeks.
In the meantime, the state can file more. Is fine, of course.
Meanwhile,
if they so choose.
Additional affidavits, if any.
The existing contract. The existing contract.
ये कह रहे हैं कि प्रदेश नहीं हो रहा है.
We have filed submissions. Filed, your lordships had wanted submissions.
Does it come today?
Yes, my lords, I was also surprised. It shouldn't.
Be ready.
Because it will require a little.
Contract will be binding.
Yes, a state.
After the
Because an employee of Telangana.
Was for the exclusive use of the state of Telangana never consented, and software there is a 3-step option. We met them, we decided, therefore the High Court.
Last time we heard, we wanted as to what kind of a nature of how much they have utilized the service.
Lordship, I will
You were saying
demonstrate.
that you didn't all.
Not at all, my lords.
Lordship, I will to the contrary immediately. I have 3 submissions. You kindly see the impugned order at page. I will just read the last 2 operative paragraphs. This court, having considered the rival submissions, made the view that no doubt there's an arbitration clause in the agreement dated 2013, and the state of not a signatory state. It was born on 2nd of June 2014. Then the question of appointing an arbitrator in clause in the said agreement does not arise. Telangana is not a signatory to said agreement. The next paragraph, Lord, is even more interesting.
दो चीजें इनका आर्गुमेंट ये है he's saying that no or has the executive. But that's an issue for the arbitration.
You say that the arbitration will not.
Lord, the next question. Therefore, this court is not inclined to
Come next week, we will hear you.
Lord, there are only 3 submissions. This can be because it's been pending for the last 15 months. In this much time, the arbitration will conclude.
2 issues. One is about the successive liability. Because in fact, of course, the second liability of the
I will demonstrate that.
It is for the arbitration. The question itself tells us how the liability How does the contract bind?
The concluding paragraph says, therefore, this court is
Shows from the provision.
now this, my lords, this court is not inclined to any applications. However, liberty is given to the applicant.
Don't interrupt him.
However, the applicant to pursue the remedies in accordance with law. My lord, the impugned order. The last. Liberty is given to the applicant to pursue in accordance with law, if necessary. My lords, if
you tell us how the liability occurs.
If you kindly
on the basis.
I will come to that, my lords. If you see the contract, my lords, the contract 28, the 2013, when the state of Telangana, page 35, it is binding. If you at the end of Finance Department, it says, shall be deemed successors in office and assigned to the first by virtue of section 60 Act 61B. The argument the state they never took before the High Court.
Binding nature. Besides the question is not a
61A as well.
I will. My lords, they are relying on 61 argument they did not take before the Honorable High Court. Absolutely. We are saying
B. Optionable wrong where immediately the existing state liability in the any optional the breach of contract liability goes only within the even these was found. If it is for exclusive says the Telangana that's found, don't use of under position Telangana. Most of them get found as per their property. Other provision?
Manoj, I am relying on my friend relies on 61A. Come to the written submissions, page 3. I will show you how the not taken from the High Court is actually factually. Miniature meetings that took place are formed. They took part in those off on those minutes when they realized in their brief submissions before this counter affidavit filed in January 24, they took a position that they those minutes. But on our written submission, they did take part. Now they're coming that the agreement was meant exclusively for the state of, which is factually incorrect.
The submission is incorrect.
Also can be decided by
indeed
jurisdiction by the arbitrator.
Yes.
Whether it falls whichever may be the position.
Absolutely, my lords.
Can I say this, my lords? 3 points. Because you deemed it fit to ask for written submissions. 3 points here, my lords. 1, I read the paragraph above. The High Court, my lord, page 3. And I'll just stop. The High Court is not just saying that the agreement. May I read, my lord? State of Telangana to the agreement dated 20.
No, because there was no such state of.
No. See, and the meeting which was held 6/9/2014. This is the meeting he's talking. Has not materialized. It was on the stage.
The meeting occurred after the stage.
Yes, but the discussion option of this software was on the stage. We attend the meeting.
On the facts.
Okay, take cognizance.
I'll take 15 minutes. any day. I just argue.
Get your written submissions. Where are
record. You filed that, so is he. He's written submissions.
I rely on yours.
Because you. Filed it, my lords. Ago. It's on the record, the written submissions.
you next week?
Yes, my lords.
May I just show of the submission?
Here we are tentative. You're tentatively. You're always open-ended. It's a remedy.
Yes.
It's a remedy. Yeah, but remedy means you get an opportunity to argue. That's all. After that, next week. After that, you know. So, you know, 22nd as well. All right, 22nd. Those days.
Grateful, man.
Is that all right?
Yes.
Okay, next.
Grateful, my lords.
Thank you. Same to you.
Thank you, my lords.
On the last occasion, my lord,
ये हमारा आपका ये सब गुरु item.
Your lordships were pleased to is necessary or not. Now there is not an amendment.
Yes, yes.
I guess its consideration.
I think so. That is state very correct. I think कोई नहीं था, that's why I said that.
Capital move में Madras
में नहीं, हाँ. No, we thought more than anything. Least way to. That, you know, you would talk to the and then smoothen the procedure.
Now the rule is
indemnity.
Any certificate by certifying that these are if you look 5 of these rules, savings, promotion, general. So page 5 of
in the principle.
Yes, Madam. Rule 9. Rule 15, Madam. In the principal rules in rule 6, the following shall be subject if a depositor dies, in force at the time of his death, of his will or letters of administration, or a succession certificate granted as or legal as certificate, the revenue authority not below the having jurisdiction is not in 6 months, so and so. Also, an alternative mode of production.
Wait, is not.
You need not have. Not necessary. Same is next.
Remedy?
Malas will need to. High Court order will come in my way.
The High Court's judgment is dated what?
Malas.
It's July.
That was not placed
Okay,
before.
May not have been
August 2023.
Yes, requested the learned solicitor general to assist in this manner to in order difficulties of legatees. The learned solicitor has brought to our notice dated 3rd July 2020 issued by the Ministry of Finance Economic Affairs in exercise of Section 15 of the Savings Promotion Act 1973. 18. Clause of the notification amends Rule 15. In Rule 15 has been amended as follows.
It's a entire can be quoted.
Yeah, I mean
86 or 86.
6 तक है पूरा कोट कर लेना. Yes, 9 तक last entity तक ले गया. Paragraph 2, the judgment of the High Court is on 23, which is notification dated 3rd July 20. They said was not taken into consideration in the order. In your
for savings bank account also, of my SLP, I've reproduced the 2000 of RBI, says that can be relaxed. Page 14.
That will only will be sufficient for your purpose.
This is only for two accounts, both savings bank account is also.
What also taken into account here?
Malaj, this is only for provident.
My officers are
In view of
my from Department of Economic Affairs. They to saving banks.
Also okay. We are also informed Solicitor General that this notice will apply to savings bank. In view of the above, we allow the order passed by the High Court. The appellants, appellants will avail the remedy as are by virtue of the notification 2023. We place on our appreciation of and the Assistant Solicitor General with these observations are
Grateful.
civil.
Grateful,
Mr. Solicitor.
Thank you.
एक मिनट में आ जाएंगे. Because
25 is methods.
As it
But
now,
that has failed.
when we told you at that time that nothing.
So, my lord, the reason failing of the mediation was only one. My lord, they wanted to reinstate. They want to pay us any back wages. They will pay. The state says we will.
Murarka told you also, we have written it also in a, that if possible matter let it be, it has to be dismissed.
My lord,
Nothing more in this.
my lords will kindly.
The matter ends there.
My lords will kindly see. My lords. What the tribunal says ultimately is the amount is to be paid by the state. Because the only thing that the state says I will not pay, the management says I will not pay. There is a rule under which and that can be recovered.
It work?
Yes.
We are ready to come back with, but at least with some fair offer. As regards reinstatement is after putting 19 years, as we have been thrown.
Watched.
Yes. But my trial court is in my favor. Well, tribunal, my lord, and the High Court says re novo inquiry, my lord. So
Do that.
I had already put in the.
In spite of those findings, thank you. SL.
Reinstatement first, then there can be a.
Not, thank you. SLP dismissed.
Statement is concerned, my lord.
You and
we need.
It can't be, unless an inquiry is automatic.
But they are ready. If that is possible, my lord, my lord, at least reinstate.
Only for
so that may be considered, my lord. That may be considered.
Yes, matter of course. Other inquiries.
Yes, my lord. Not an employee.
Not even proceed without.
You can't insist on the.
My lord, let there be no. Then continue with this phrasing.
Is redundant.
That if they have to initiate against you, if they don't, then they go file a complaint. Ask them to take the whole inquiry. Yes. By making, you will be writing something against you. That tomorrow we did it only because the court has.
May kindly direct to immediately reinstate. These are there for.
Thank you.
Because the reinstated continues. That's why I am asking for my lord, because we had shown a judgment.
Unless they pass an order, unless they pass, putting you under suspension, then challenge that. This doesn't require it. We thought that's why we referred it to.
We also wanted to put the management doesn't want to the state, but the rule says that if there is to be paid by the state to the, they can deduct from that amount.
That's 43.
May it please, Lordship. State of hearing, Your Lordship, is directed to file an affidavit whether on the day she was dependent on her brother or not. During this period, the notice asking the respondent to submit a dependent or not. In view of the correspondence, Your Lordship, we have obtained an Sildar saying at the time the was dependent along with my mother and the brother. That certificate we have supplied to CL also, and we have filed along with. Now, Your Lordship will kindly see at the time of my application for compassionate appointment not taken. The only ground on my application for compassionate appointment was that there is no provision to provide a register. That part proposition is concerned. There are judgments which are taken into consideration while passing the impugnment. Done, it is gender discriminatory because it can be provided job
not to be deep to English.
Well, my submission is my lords have a number of judgments and others. I have so much reason that this is a scheme, so it should be specifically of the scheme now happening, and that's what we are afraid of. Well, that's exactly what we are afraid of. what had happened at the last instance, what my did. Well, it's divorce, whatever the merit. Well, it's what has happened, what will happen again, because there, which was cited by the High Court, a preliminary finding without any observation, that is being quoted as if the entity has been now modified. This goes to National Coal Wages Agreement.
The scheme cannot have a gender bias. Scheme cannot have a gender bias.
Well,
what is the foundation on which the High Court has?
That's exactly what I'm saying.
Have a look at it on this point.
On the National Coal Wages,
on the basis of
this
on the compassionate appointment.
I'll take a look at it, but according to this is compassionate appointment in terms of and lordships. I have a judgment. It has to be clearly governed in terms of the which emanate.
Mr. Banerjee, if the scheme that only people with on the head will be appointed as not the others, will it be a scheme?
Because this is a compassionate discretionary scheme. I'm sure those will also balance compassionate appointment right. Well, if lordships are rights, then
it's not a question of right, it's a question of discrimination. And number two, on this incompassionate appointment, there's a
I'll take a look at it. I'll come back. And that's why lordship asked us to find out.
Discriminatory matter, it's there.
Well, it's twofold provision, 9. It says if you don't directly in this category, then then you show that dependency. That's why they asked us to find it out from our side. We had a number of letters in our compliance affidavit to respond. They got this affidavit from the on their own, from the tehsildars on their own, without, and then sort of provide, this as a fait accompli to us. But we are more concerned about this sort of modification. He provides for them. The scheme does provide for them.
Check that out. Pick it up next Tuesday.
Next Tuesday.
Tuesday only.
Yes, Tuesday.
I'll take a look at it.
Cannot be
directly.
Well, my girlfriend wants to mark already given to the son. At the first, then the son dies. Now the that's what obliges.
Say appear for the petitioner. Item.
But I appear for
petitioner. Service is complete and pleadings are also complete. The central administration directed the respondents to consider promotion. That order the High Court in writ petition. Plus this for the post of assistant. Plus the recruitment rule in level 4. The person should have 9 years in the qualified service.
Clock better.
Please.
My lords, have it next week. After
Be done in this
after lunch. Okay. Not okay. I heard my lord say 2 p.m.
Not today.
Not today.
May I please, lordships? It is an endowment property or personal property. On this question, it's our 87 pages for the commissioner, as directed by the Honorable High Court in 19, and the same has not so far been and they are initiating another and which resulted the tribunal allowed their claim before the High Court and the CMA is dismissed. May kindly be seen.
Purchased from Pujari. Says that he.
In 52 onwards, we are in possession.
It's a temple.
It is a temple.
And the suit preferred by them also was dismissed.
Sir, of the impugned judgment, even if private land in view of the previous order.
No seal here.
Can be seen by your lordships.
Paragraph 2. Paragraph judgment.
Yes, yes.
When notwithstanding this dispute as to trust land, your order it is unauthorized.
Even otherwise, section.
Kindly see 11.
That CMA order against the section 87. That is what happened. That's still.
May I see this? Lordship, may kindly come down. Annexure B1, the judge High Court. That may kindly.
What happened? 87.
87 is still pending. They have not disposed of them. Let them be directed to. That's all.
The state.
It is
When
sections
dispose it
Lordship, they have just sent it and then
Not even for
Kindly
pending.
Kindly see page 35 may kindly be seen. And right hand side of 87, they have received the same. That is the owner of Karyalayam, deputy received the same.
What are you saying?
PCP 54 Lordship. Page 50.
Page 50.
Radhakrishnan's.
Yes, minutes.
The section
87
Act is filed before Commissioner Endowment.
Kindly see page.
Yes.
And page
Page 4.
4.
Yes. Yeah.
OA order, my lord.
It is the.
That we have seen last
While
week.
so they defend.
But then this is there with stamp.
And why that?
What is there at 54?
Kindly see. While so the defendant hearing not complied with the court, assess the plaintiff hearing filed petition commission endowment, so on, revealing the fact, to which issued a notice to the defendant hearing before the court. For the day the defendant appeared and misled the commission, stating that she has complied the direction.
But then this doesn't say anything about your.
Is there pleading before the
Come back. You dispose of. Has brought to our notice the petition. Endowments Commissioner under section 87 also indicated is also enclosed. The said petition is with the special petition as annexure number. The said is stamped. What date we don't. Council petitioner appearing on behalf. Instructions about the
7-8
application. And we will keep it pending or we will. If the said petition the same within a period of
yes
1 month from today, 2 months from today, this matter disposal in the month of July. And after July, whatever is the outcome of it, you abide by that.
Must be done.
In this, we
They have not
dispose it
filed
on-
within-
there is matter. Let them
dismiss it on delay.
They have not even filed, my lord. The High Court.
they have
They have instituted it.
You don't notice the
Let's page. Your Lordship, we have filed the page. Possible by the High Court. Page.
They can challenge that.
Direct plus.
month in July. Come back.
Yes. Okay. Great.
My lord, I'm speaking file rejoinder. It's there, the signed copy.
After 2 weeks. Next.
For a passover in 47.
Lordship, I'm question, Lordship. 3 weeks time.
No, my lord, my lord, there is no reply needed actually, my lord. Lordship.
It is not needed, Lordship. He filed the Lordship, and even he paid code 200.
What happens to the suits?
The suits are still pending, my lord. My lord, 68
against only encroachment.
The allegation, my lord, is that you
Lordship between petitioner and
I don't know.
Let them decide the suit.
My lordship indicated, my lord, that it may be said. My lord, let the High Court examine all these facts.
Lordship is pending. Yes.
My lord, the suit is not. Lord, sorry.
The repetition you want the
No, my lord, not at all, my lord. My lord, the repetition, lord.
to change the prayer in the suit.
My lord, it's not my suit, my lord. We will just have the prayer of the repetition. Lord, my only allegation was there are encroachers on my corporation has taken action under section 52 of
pending. How can in the repetition High Court?
High Court without calling for a reply, my lord. My title, my lord, in the WH in the suit is not. It is, the suit is filed for a different reason.
That, but
no, that is why my lord request Ms. Devan. Pass over, my lord. Ms. Devan is leading me, my lord.
there in your
Yes, my lord. Lordship will have the 74. My lord, all this, my lord, just the order is passed, my lord, without even calling side, my lord. My lord, have a head, my lord, in Bike. That without even calling for a reply, how can you shoot it? No reply was called, my lord. This was not when the MP order was passed. 170 petition. The prayer is on page 265. No, only prayer is that the action. That's it, my lord. They have already initiated proceedings under section.
for the corporation?
Yes, I am. Lordship, I have that's what the 3 weeks, Lordship. Just recently filed
there in the matter.
Lordship.
Well, I am only praying.
You just check up and then anything which you have taken action, we will dismiss this.
Yeah, yes, Lordship.
You stay.
Lordship,
just take oral. We don't need to adjourn this matter. Take instructions about the position of this complaint. He's saying there are encroachments. Instructions and come back.
Not as per their own documents.
Lordship,
they say that there are issues of possession and those all I am preparing for 6-2. My counter.
And over which encroach.
It's not the public land. The land you. Yes, I will take
instructions and come back. And the others case.
No, yes, this is the fact.
File the proceedings. No, he has not filed those. I'll place them on.
Tuesday.
The corporation has taken action or not.
Yes.
Lordship, at least 1 week, Lordship, because submit some documents also.
Okay, Wednesday we are adjourning.
For next.
Next. Yes.
My lords, I'm requesting for a short 48. Yeah, your lordship may have it after a week.
Pensions being after 4 weeks. Next.
Lord 49. Advice. I request to pass over, my lord. I'm led by
the day. We have 80 matters today.
49 2 p.m. slot. Because I didn't heard.
Feeder category should be treated as a feeder category is what.
Data contact needs to be heard. Yeah.
Clarity is all right, but seeking for that is a promotion. The category is post after 4 weeks. Or not 3 people. 2 people. We'll hear you.
All.
We'll hear you. We'll give a date.
Yes.
It's a journalism. 15.
The service is complete to the last time. Respond.
Council of India, Your Lordship, in this matter.
Council of India.
Your Lordships have been the last order. Your Lordship only completed us. The first time we are appearing.
This we'll put it up at 2 p.m. We'll hear this matter.
Your Lordship file a short affidavit or seek. If your Lordships are framing some issue.
Next.
Please, your Lordship.
Wait, please. Asia has failed in this matter, my lords, for appointment.
I'm praying for a pass through. Man is leading me.
Tuesday or Wednesday.
That's what I'm indicating it.
Yes, they will give a date. Next.
Manoj, this matter was mentioned by the respondent. We grant 2 weeks time to file the counter.
After 2 weeks.
Please, my lord, there was a short point on the last date. My learned friend and your lordships have been kind enough to give me time. This was on the question, my lord, insurance contract. When there is a the claim can be. My lord.
So long for this matter to come back. When was it listed?
Last date, my lord, was. Lordships may say. My lord, there was judgments. My lord, the answer is very simple. Judgments, my lord, referred to the clause as a
Different bench.
yes, my lord. I mean,
No, we heard from 97.
the 97 amendment was what was an issue.
सुन लेंगे छोटा सा है. Wednesday is okay?
Please, I'm not late.
Waiting for responding.
That's the
Please, 2 weeks time for filing a rejoinder. Have mediation, my lords, because suggested that mediation can happen.
Okay. This notice was issued for the purpose of settlement between the parties. Happened? Any?
My lords, we are only on the last date. They have appeared. Lords may refer us to mediation. I can also file.
Matters.
Please, my lord.
My lords, I'm appearing for responding. If page 19 can be seen, my lord, shows that I made the available on 14th of November. My lord,
Mediation will come back.
When your lordship says we can find a rejoinder. That is
will be complete.
Please.
But the item, this matter is coming. Since my lord, both have a partnership dispute, matter be say.
Mediation. Send it to mediation.
Please.
Next.
Are you apply?
So, my lord, if I may, short pass over because the lead counsel on the instructions in the meanwhile.
You'll refer and work it out is better than who is
whatever
appearing?
falls
Who is appearing?
Arun Shukla, advocate on the court.
Center will be, if I will inform.
On current findings.
Yes, Milord.
Filed a response.
Leadings are
Strength and speech. So, notice किया है. Granted an interim order to you?
No.
My lords, there was no ink.
2 PM पे लगा देना. We'll hear you.
This side of
This side we don't know.
my lords, because
To go and ask, we'll give you the list of all the lawyers. Matters are fixed at 2 o'clock. Persuade in their place, we'll give you.
my lords, the urgent, my lords, I can only seek an accommodation.
Dates are filled. Next.
Then grant a fixed date in July.
Yes. Next.
A fixed date.
But in this case, yes, a short notice for teachers.
Notice.
Because we were appointed when the state set up polytechnics. We are BTech and MTech. 82% marks on merits. We were appointed initially for a period.
Notice, right?
Yes, yes.
That's ISF.
Grievance to be, why not should issue a short? Lord, we have been serving Lord.
17.
Yes, and Lord, 82% we are meritorious. Criminalization, we had an interim order in the High Court. Because I went to the High Court, they have terminated my service. And Lord, I have now placed on record the chief on that these fellows are meritorious for them, but they have gone to the High Court. Lord, how can a chief minister say that? Therefore, we will not do it. It's on record.
It can be done for them.
Well, they are already going. Some kind of relaxation is being given. They have participated in the recruitment process.
Prime.
They are absolutely the Calcutta thing which happened yesterday. I am paid in that. There was a very different case. This is not that case, so it should not be colored.
In fact, they have already participated.
That's all right.
In the recruitment, my lord, they are already participating.
All are not participating.
Which they are under consideration. You file
and whatever you do, young teachers,
service.
I will do that.
They are otherwise not entitled to regularization. Their services continued since the orders of the court.
Please. We can't apply. This was the case. Teachers for a polytechnic.
They only work for 2 months.
The present.
See what you can do.
This on record.
What you can do.
We'll place that. We'll place that on.
The posts which are available.
In the meantime, may I please kindly allow me? My learned friend was here on Tuesday. I gave him the details. Now, what has happened is, which were clearly they find the technical in a process because on the face of it they were not. Now, same day on second, last date on second they disqualified. I want to remove the basis.
Our intention was to see that if he has some. If it becomes a regular litigious malified, intentional and all that,
advantage he was there.
No, I am just on. I'll come to the core issue. But what has happened is, right on second,
they are gone and then what?
Entire process. Look at the entire process. Technical. Then
was discrimination.
That's not a removal of the ground. That ground has not been removed. Plus, what has happened is.
Instrumental in to that extent you should say
a good thing,
but to say to the next ground that is a legal.
So, hear me on that one. Normally, if technical bit, you open the financial. Once you open the technical question of because the entire process is vitiated. technical, allow them in financial, open their financial, disqualify them based on the technical.
The sense that they found them, so therefore they have removed them. Those who have the eligibility as are the ones who are in the frame. If they are financial bit, they will be taken.
And what has happened, because many of the areas, only one, effectively all the ones which who remain, they've given it to the today. Your lordships will not consider me kindly.
Will not be the basis for setting aside the entire. Leave it at that. Thank you. Selfie.
Grateful.
Your lordships, I'm seeing addition on
this act and all of those two acts which have to be considered. While the 12A,
You both sit together.
I think try
not work. Okay. We hear it. Please, you'll hear it.
Yes. Because it's an interesting question of law either way.
Very important and interesting.
Because argument is we are a social institution, we are holding the monies in trust.
Really, we'll hear you. He leaves everything.
Item 16, that's a finally in order to list the matter on NMD.
60 is it?
Yes, ma'am.
After 2 weeks,
Much of
no need for final disclosure.
Eats.
63. What remains now? How many rounds?
Against
Who's the respondent? Who is the petitioner? Similar matters dismissed.
Similar matter, same order.
Have different facts and circumstances. I can prove.
Don't work.
Give me 5 minutes, I'll prove it.
Not necessary.
We have clear-cut data also. We have social justice was compromised.
No, sir.
So I prove how it is.
Yes, sir. We can't because. No, not necessary. Thank you. Yes. Next. 65.
Wait, please. Order 13 decree wherein in para 36 court says a probable defense has been raised by the defendant, despite saying can there be a interim
Admission.
No,
There is an admission 20 lakhs.
No, I have paid.
You have paid 55 lakhs. There's an
Illegality in the order.
Then there's
No,
nothing.
there is. Clarify that.
There's no illegality.
I'll clarify. That's what I also thought. But then 1 point repaid. Trial has shown that plaintiff gets on the box. Plaintiff had yes 1.31 crores was paid, but I interest. The plaintiff keeps. Because my only thing is please 38 also, Lords. Then I'll stop. Para 38. I am not going into the merits of single judge's order, the original order. The Lord
Argued in the High Court.
colleague had argued. Because I'm at page 2. This is the single judge's order. Please see para 36. Lordship has it, Lords. Bottom of page.
Is an and budget. 70.
Yes. Plus 207, I'm sorry.
सर ऐसे मैटर्स में कहाँ है? 107, yes.
Yes, because the last, I just read those two paragraphs. Insofar as limitation is concerned, defendant has made out a probable case on the ground that the suit is. Malad, I'm faced with a unique thing in the suit. Then Malad, injustice to me is Malad's grave. That's point. Then Malad's the next.
Restored.
Then Malad's the next paragraph. Please see para 30. Without expressing any opinion on respective contentions. I really don't understand how can there be an interest without going into merits. But
These are all.
But I'll tell you a lot. It's 1.5 crores. Crores is the suit.
Still not our.
Then, Lord,
this is still not our line.
May only make this request. The trial is fast pace. It is likely the next 2 months, and it's commercial trial before the master. Only saying one is your lordships may say that expedited. Until then, my lords, and my lords, all right, my lords, in that case, can this be, my lords, kept in, because it becomes an executable order. Then, my lords, only one request: the issue of limitation is left open. That is there in the order.
It is there.
The order is there. I mean, there need any clarification.
Do you want that?
It's
Do you want it?
No, it's already there. It's already there. Invitation. But in fact,
The issues would have been struck with cross-examination.
Because I'm only saying, Lord, defense is making
also there. No, Nikhil.
it is. All my defenses.
Like,
Lord, as of violation, because in 19th of February, FSI increased. See page 8 of the additional document. Architect certificate today. Lord, permit for the building as it is.
That is
Page number 8 additional. Lord, my application.
yes.
Lord, my was just a proverbial slip between the cards. My appeal was dismissed on 13th. Lord, 4 days before, increased into force, and the appeal appears to be paper appeal. No personal was not brought to their attention. Lord, in a similar matter, Lord, has been stated. May I pass on this honorable? Lord, it depends on cases too, but this is.
Demolition is precedent. What matter is same impugn order?
Not against the same. Again, what happens under the 25-year-old buildings? Mine is the regularization preference.
You are talking about 2019 order.
But this is in 1990. Leave has been granted thereafter. And Lord, I am in the same position. What I am asking is this, my Lord. My is
like saying this house is so sat on the coconut tree.
Lord, today.
There is your house. It's where the crow sat. So wherever some order of demolition somewhere to do with you.
Lord, two things, my dear. Order of demolition is one similar. My Lord, a regularization was pending. Here the facts are better because your Lord, today is the FSI. If your Lordship sees page 8 on the facts.
No, sir. Thank you.
Lord, may I make this request, Lord? Lordship says I wouldn't trouble your Lordship so much blatant injustice, my Lord, because Lord, it's FSI is 3.5 and bring a building of 7,088 square feet, my Lord, exacts about 400 square feet less, my Lord. And today I've kept the building seal. I'm not saying anything. Please stay. Petition is over. Decided. 2 weeks if you wish, because page number 99. If you have a minute.
Sir, thank you. Thank you.
Yes, 5 days before. Would you
We have heard you.
My lord, your lordship would give me some breathing time. Is over. But my request is
My
request is this. My lord, would your lordship just
and then ask for time.
my lord, the demolition is this small.
My lords, if my lords, may I only state one in addition? My lords,
He's the other side.
No, my lords, my lords, there's a dispute amongst the partners.
We are not concerned. We are not even a party.
My lords, may I only state one issue, my lords, if your lordship permits.
SLP dismissed.
This request, my lord, your lordship, the bench that I could go back to the High Court commission. Lord, would your lordship then come back if I lose there? Because on a very, very limited issue. Lord, Lord, I'm saying is, my lord, I'm
Petition, you withdraw and file a review. But there is a question of you. So dismissed. Don't invent new.
Review is not. I haven't
SLP dismissed.
Then may I withdraw with liberty to go for
Wrong.
with your lord? Otherwise, Lord.
I will not grant you because it's a simple order of demolition. Extension of time we would have granted you. Permitted you to go at you want to withdraw, we will permit you to alternative remedy that you may have.
We'll withdraw the
67 is granted.
Time is granted
for extension for vacation.
Sir, I applicant, my lordship.
On other side.
Sir, it has been served. Circulation letter was also served to them.
What are you asking for? You are asking for
time, 6 months, my lordship.
When did you file? When was the Supreme Court's order?
31st March.
When did you file this?
Before 31st March, my lordship.
When did you file?
29, my lordship. 29.
The side is there. How much time?
My lordship.
Serve it on the other side. It was appearing, usko order come in. नहीं लग रहा है नहीं करना है. Why should we?
My lordship,
routinely you file extra time for you. Oh, this is over in November. What more?
My lordship, they limited shop by a applicant. So dependent.
Substantial justice.
My lordship, only 6 months is required. 40% things are there.
Fair at all.
My lordship.
I don't think it's fair at all. So, what? Appearing, at least have you served a copy of?
Yes. Supplied miscellaneous application, earlier circulation letter also. That the case is listed today.
नहीं करना है. तो content dismiss.
It would be great if you could consider.
Ask the court.
Okay, my lordship. Then in that circumstance, lordship, 3 months.
Serve it on the standing. We'll do it. The advocate who appeared.
Within 1 week, my lordship.
Do it immediately.
Okay, man.
Mention to us.
Okay, man. Grateful, man. Grateful.
Orders.
Okay, man.
Next.
Is that very please, your lordships. This matter in obedience to your lordship's order, an exercise was hypothetical exercise was conducted, and only 30 candidates are one of consideration.
Put me in list. No orders.
Most of them are not coming within zone. They are given credit for the questions.
On Monday or Tuesday?
I just wait.
Go through. But too many matters got added in this.
Yeah.
Tuesday.
Fix it at 2.
Sometime high in the list.
Yes, Monday kar lo.
Tuesday at the top. If your lordships can. Tuesday at the top.
Tuesday.
Earlier.
Or it fixed Tuesday. What is the question?
Yes, please.
This week as item 47 in the supplementary.
It wasn't listed, is it?
Yes. Yes. We have to mention it for.
It is. You haven't lined up. Tuesday का list. हाँ लगा दो Tuesday. Sunday लग.
Right.
Tuesday भी.
Open.
Will be under suspicion. Will na? Reversing order. Will grant leave in this. Leave granted. Continuously reversed.
Submit
one thing, my lord. Hello? May I submit one thing, my lord? My lord, kindly grant me the count of date I want to bring to
No issue.
just 3 weeks time. After that.
Meanwhile, yes, we have granted.
Last week, my lord, the matter was admitted by your lordship.
It is covered by ISA exim of your lordship.
The judgment of the High Court earlier order in Nina Uppal was a union. In civil appeal 4502 of your lordships have admitted that. That order, this is regarding to class Supari.
So that it is not fit for even consumption.
He's never even seen it. Yes, sir, Kanath, what is to be done? To post it along with some of the matters.
No, this has to.
Your lordship has indicated off.
No, I submit, my lord, that this follows Neela Uppal and that has been.
Lord, in Nina Uppal, they were.
You may see the judgment of the High Court, they follow based on this judgment.
Mr. Dwarkana, slightly different. It's only the release of the.
Yes. Only, my lord. That was the court records it like that.
Lord,
what they are telling is ruling which the officers now that decision was
last time. It was mentioned by who?
ISA exim order.
Order of this
Isha exim.
ISA.
Remember after that order, my lord.
That was
sure.
Case of classification dispute.
Here also a dispute over the classification.
Advance ruling, they have followed minutes some which they
therefore, other this appeal and delete.
From that.
Yes.
The release of the groups only to consistency will be dismissed.
No, my consistency purpose, this appeal should be.
That one shows that admitting order.
455 million. Last week it was there. But
that he mentioned it.
Your lordship will see the impugned order in Para 3 specifically records. I have considered based on the decision in Nina. And when that appeal is admitted, my lord, act on with that.
In those cases are
different, my lord.
The facts here are detention. It is detention case. The product in both cases we are telling that there is fragment kernel and that defeats it. I considered in the lower court that and then when that is in appeal also has to be entertained.
Lord, in Nina Uppal, they were arguing the consumption.
No.
They did not
admitted.
Slight difference Prakash is pointing out that it was not fit for human consumption.
There
was some dispute.
that the impurity is posed off only on the ground that it is.
Isha exam, I am covered by Isha exam, and Nina made by the learned ASC.
Hear it along.
But codes are already released.
On a principle, it will stay. Order. It's only on a principle.
Not explained, Lord. 170 days delay, Lord.
The central government is also. Post along with that. Post along. No interim order. No interim.
The request your lordship may convert the delay and post. It was civil appeal, my lord.
You've done that.
The moment if I will point out the reports. Lord, if I will appeal for Nina.
What we will do is, we are not granting goods released will be released. We are not. All that we will do is, assumed order is based only on Nina. We grant leave and post it along with.
It's just one point I want.
What do you want?
Last day, learned ASC, Mr. He had pointed out that the only difference in that in that case there was a report that the goods are not. And in our case,
Yes.
Lord, the human consumption. No. My lord was only convinced. This is covered by Isha exam, Lord. That is why.
Sorry, my lord, that is not the case.
All right. Next.
May it please my lordship, this is
Against an interim order.
Sorry?
It's against an interim.
No, lordship, the difficulty is that the High Court of Allahabad in July 20. Readings were complete in September 20.
Listed for 17th February. It would have...
No, so lordship, I'll tell you. So then on 17th March it was listed. Then it says Passover. Lordship, 6 applications have moved.
Against an interim order,
So,
hearing specific date is also given. There is a question of you filing an SLP agreement.
just indicate, lordship. So first with this, which my lord asked, on 17th got passed over, on 7th March, 17th, again it got passed over.
Surprising, sir. The High Court is not doing any work.
No, I'll just indicate what
It has just got to some other day and you file.
Yes. I'll just indicate why. Number one, the hearing is given to cases of facilities by a number of high courts.
We'll make an observation.
I'll just indicate. So one is the Delhi priority hearing. I am carrying the circular.
Sir, you don't need to cite it. We'll tell the
Lordship in the so if they to consider it, why? Because there is a 16th April, the next exam is happening. So that seat which I may get taken away by then. So if it be requested to take it up next week, that would serve the purpose, Lordship. Otherwise, it I'm sorry.
All right. While we are not inclined to interfere by the High Court, facts and circumstances of the case and the petitioner being the candidate with disabilities, we request the petition, take up the petition and this petition as possible.
If my lord may say, preferably in the week.
Not be saying, sir, this itself is an exercise which we'll do, but it's an exercise we have done it.
Yes. Obliged. Thank you, Lord.
I appeal for this. I have also filed an SLP. There is an order application for tagging as allowed. However, that matter. But the request.
Should you file against an
Lord, that is, it's not a judgment.
Point number 1. So the
71.
72.
72.
From disposing or making.
So filed an SLP that is not listed on board.
Also just got the matter. We'll take it up.
I can. Yes, on the
next date before April.
Lord, my sales are. Plus Tuesday.
936. SLP civil 936.
File the petition.
Favor of the you are at
Phone number 4 is not able to say.
I'm the agreed person. I'm 14.
I am the. My lords, I was.
Any
My lords, that is not the issue. My lords, I am. That's not affected at all.
Yeah.
Yes.
That see. But may I request?
We'll list all the matters and this for Wednesday.
For Tuesday, if it is possible.
You've already listed large number.
It's
already.
ठीक है Wednesday के साथ वो नंबर दे देना उसको.
As I beg to appear in 73. The petitioner is 81 years old. He was married to respondent number 2, my lords.
Covered by the judgment of Ashok Bhushan. Every right.
Well, she has stopped her from staying, my lords. That's what had happened. Directed to vacate from the house.
Yes, because
but mother's
family settlement, she has.
I am now, mother subsequently. May I just make one submission? I'm 80. My wife is staying in that property. I don't have another property, my lords. I'm remarried. She's been remarried.
For our purposes,
Mothers,
that is the application of the
mothers, the mother-in-law's permitted. Mothers were kind. 120. Mothers were kindly. Mothers, my wife is permitted to. I've been directed to vacate from the house. Where do I go, my lords? It is.
You've got others.
Well, it's only once. Well, it's only once, and the others have died. One submission. That's only considered. Now remarried, my lords. It's a house with 8. Stop her from staying in that house, my lords. And my lords, they're on caveat. So if they can try and resolve this, my lords. Just because I had a. Must be considered only just one aspect. Onwards, she's not stayed in that house.
Succeed all through and argue. Whatever the court.
Mothers, the High Court has not considered this point. The right to stay in the property. There is not even a.
For her to contest and all.
Can I speak to them and see what I can do, mother?
Work it out.
It's a marriage of only. And she's not. She's now remarried. 2008 onwards, she's not staying in the house. Before the High Court also, my lords. Where I go, my lords.
Thank you.
No, just after 2 weeks, let me see what I can do, my lords. That's because.
Notice questions.
It is an anticipation.
Take out notice. You're issuing notice.
Well, interim
I mean, let the other side serve it. Well,
has been granted bail. My lords, I'm
no question. Then we. Yes, we are granting you.
Very good.
And that's what statement data order.
Let's P6 is the
Other side, they find. Then I can't go accused.
I could.
Notice.
Where is that order?
36.
Next.
Great.
Right, please, lords. These are the matters your lordships were trying lords. I have moved an amendment, lord, because the separate order somehow we lord I bench. So that's a formal application and we consider it and allow it. The scope is this, my lords. Yes, my lord, the scope is the issue of legislation is staring on the face of it, my lord. The sale date, my lord, of which they declare to set aside the sale date, my lord, 1/6/2000. And admittedly, my lord, they acknowledge and they note the date, my lords. Commentary, my lord, of objection in 2000, page 67. And in the mutation proceedings, my lord, the plaintiff filed objections in right. Page 67, my lord, is objections. And 10 years thereafter.
Page 67 is
67 is his objection in mutation.
dated.
My lord, that is dated in 2000. Please, the objection is started and kindly come to page. Yes. Just want to show page 67, para 4. That the
As in the suit.
sorry, what sir, my lord, the suit is, and for declaration of the
If
suit.
it is
For
then
the
Article 65 will come in. 12 years.
My lord, the publish.
12 years. Truncate players.
No, please. Question me, please. The names
are A and B, and B, the suit is maintainable.
No, my lord, this sir. The suit, my lord, is the primary player direction of the
Earlier.
field D. Inside the field D.
Asking for declaration, it will be 3 years. If he's asking for possession, it will be 12 years.
No, my lord, the field is not set aside. Cannot get possession.
Correct. That is not a point.
So my submission is this, my lord. At no stage the has been considered. With great matter came up on the first round, your lordship. The point of limitation has not been High Court. We went back. Says, my lords, now in the High Court that we have not. I am not in the review petition, but completely melodic correct. Otherwise, what will have secondly the limit? The Lord is suit being lords. They are 11 years and this issue has not been decided. Because I am in possession, my lord, since 2000 under the varied CLD, under and second aspect, my lord, the other matter is this. Our ground, my lord, for cancellation of the same is this, that the power of
That's the whole argument.
Yes, but no, that is not my the other side. The power of attorney have been. Now the law requires section 200 notice of revocation, my lord, or to have to the attorney. Now admit notice, my lord, has been given. Notice has been given, my lords. And finding, my lord, in the judgment is where the attorney was aware, but when he says that it was by a written not been placed on record, a UP is produced on record, this was sent, but mere UPC is appreciate a certificate proof as to what was communicated under the UPC, the Lord. UPC is not on record, my lord, even though the was examination that letter for the sub registrar before the Tehsildar, commission of the letter and that letter.
There, Mr. Stevens.
Now, my lords, I'm in position since 2000. I'm a bona fide and my lords, the got to have been decided, my lords. The court says, my lord, the court says that it's a mixed question of decided at an appropriate stage, and the trial court that does not decide it at of limitation.
7.
Yes, sir. It's an application.
Yes, sir.
Sorry, my lord.
Yes.
Sir, I have a SLP to already filed my SLP. Now, first hearing, my lord.
It is an election petition. So
Yes, my lord.
What the principal petitions are, material absolutely necessary, and is correctly allowed.
It is not correctly allowed if you the grounds abuse at all, my lord.
Election petitions cross the
My lord, can you repeat?
Tell us, we want to hear you.
Sorry, difficult to hear you.
All right, tell us what is the best point that
My lord, the base point I observed on the election, the result pertaining to Vadodara, where from last 4 election, party is getting 72%, party which is Congress getting 24%.
Problem with
Mm-hmm.
711 is not validly.
My lord, why it is not convinced me, and as per the law, like an allegation referred to election, thoroughly investigated. There are submitted in High Court, and the reason something is very severe, like voting is changing. Still, the winning party is getting percentage is a very big. Based on that only, I raised this concern.
Item 42, my lords.
My lord, we are ready to accept statement, my lord. We have also back pages, my lord. At least she'll be getting some.
My lord, reinstate.
They are willing to reinstate.
That was there. So they forgo the back pages and the inquiry is dropped.
Yes, my lord.
Because he will have only a few years of.
Why didn't you tell us that?
Yes, my lord.
And for the state, the management is not here.
We've intimated them. Yes, they are.
All them.
Let's see if there is.
But has he?
He was here. He was here.
Yes, he was there, and they are agreeable.
We are ready to reinstate, my lord.
We'll have to record it.
Yes, my lord. Which is going just because my lord, 18 years before her termination. Item 42, my lord.
Okay, I'll do one thing. Come on Monday.
Yes. Oblige, my lord. Oblige, my lord.
No, sure.
Oblige.
Oblige, my lord.